Welcome to another Fireside Chat. I'm Marty Pospischil, and our very special guest, Carolynne Maguire from Maguire Company, Notary Public, has joined us to speak about another exciting topic, which I'm super pumped about. It's very applicable, is the Landowner Transparency Act and Registry. So this is something we've all heard about, read about, seen articles about. Unless you're involved in it, it's kind of like, oh yeah, that's interesting that the government's doing this, probably a good thing. Doesn't really apply to me. Maybe it does. Maybe you'll realize after today's Fireside Chat that there is an application that you should look into, or maybe it does apply to you. So I digress. Let's start with Carolynne, what is the Landowners Transparency Act, and who does it apply to?
Well, I think the initial reason the government had behind it was, of course, to assist in the prevention of money laundering and to, just in its own name, create more transparency for, who really owns real estate in British Columbia.
Right.
What's going on behind the registered ownership on title.
Right.
Okay. And so they've created a separate registry for that, the Landowner Transparency Registry, or LOTR, formerly, used as an acronym for Lord of the Rings, but I'm adapting.
I like that. I'm a big Lord of the Rings fan. Okay, good. Maybe there's an analogy that ties the two together.
So they have their own registry that is separate from, but somewhat, coordinated with the land, what we call the Land Title Office, but is now the LTSA, the Land Title and Survey Authority. Mm-hmm. So if you hear me saying LTSA, that's the Land Title Office.
Got
basically.
it. Perfect.
So that's what the government had in mind. But I will say, one side of me also sees them benefiting from this legislation as being able to monitor more carefully the beneficial ownership of this real estate in British Columbia for tax purposes.
Right, because, if I could interject, beneficial ownership agreements in the past, with my experience, were something that could be arranged outside of the title on a property.
Yes, because the Land Title Office only registers legal ownership on title.
Right.
In other words, who can sign the transfer document.
Right.
But it doesn't speak to what's going on behind that in terms of where the money came from, who has control of decisions about that property, who benefits, who should be paying tax on those benefits. All of that was not something that the registry made apparent.
Right. Okay. Very, very good. Okay. So who does this apply to? That's the big question.
Well,
can I ignore it as a consumer?
No.
Or
at your own peril. Significant penalties.
I can only imagine. And on that, who does it apply to? And what are the reporting obligations?
Well, so it applies to all BC property owners.
Okay.
Everyone. So either you already own property or you are going to own property. Should at least have given it a look-see. Now, whether or not there's a reporting obligation is the next question. So when you go to buy real estate now, your conveyancing practitioner will have you sign documentation that pertains to this whole other registry. And at the very least, you're going to be signing a declaration as to whether or not you are a reporting body. That's a term that they use in the Landowner Transparency Act.
Got it.
So reporting body would be, without getting all into the legislation of it, a situation where there's more to the story than appears in the Land Title Office, the LTSA.
Yeah.
So relevant corporations, partnerships, trusts, all of those kinds of entities that have ownership structure in the background, automatically reporting bodies.
Okay, fair enough.
So anybody who had been owning real property in BC who was one of those entities was given until sort of late last year to catch themselves up and report.
Got it.
Okay.
Got it.
So hopefully everybody's done that.
If you haven't, do it now.
But whether or not there was a trust involved is a little bit harder for some people to wrap their heads around.
Right.
Yeah.
Right. Okay. All right. And are individuals ever reporting bodies? That would be my question, because the majority of our clients are individuals. That's
exactly what I mean by it's a little bit more difficult to establish whether or not there's a trust. Right. So that is the perfect question.
Okay.
It's less obvious for individuals.
Okay.
So the kind of easy question to ask oneself is my beneficial ownership in this property an exact match to my legal ownership in this property?
In most cases it is.
In most cases it is.
Right.
In which case you can declare that you're not a reporting body.
Fair enough.
But if you have control over this, if you're a beneficial owner for more than would appear at the Land Title Office, then there must be someone on the title who's signing for you. And that makes them a trustee, and there's a reporting obligation on a trustee. And even if that's by way of a bare trust, which is more common than you'd think, because they're fairly simple and accountants recommend them all the time, and it's one of these things where if your circumstances benefit from that, then that kind of documentation should be put in place.
Okay.
But it does create a reporting obligation. So there's nothing wrong with it. It's just an extra step that wasn't required before.
They want to know. So if there's any kind of agreement in the background with respect to the ownership that's not on title, that's where this act comes into play.
That's the idea. That's right. So
fair enough. Yeah.
It is new legislation. So there are very few experts out there. It's still something that hasn't really made everything clear to everyone yet. There just haven't been enough years under our belt to see actual examples, in the courts and things like that about how things are interpreted.
Right.
But the best we can do after reading the Act and understanding the expectations of the Registry are, as I say, summarized with, if there is beneficial ownership that is other than registered ownership, it's a red flag for a possible reporting obligation.
Right,
yeah.
Right. Can you give me an example of where a bare trust might be used?
Yeah, absolutely. As a matter of fact, last time I was here, we talked about different kinds of ownership. And one of the examples we talked about then was, say, a parent wants to add their child to title as a joint tenant.
Right.
With the idea being that perhaps they would avoid probate and save some money there. And I would refer you back to that other discussion for more detail.
That's our co-ownership Fireside Chat.
But so without going into too much detail about that scenario, where that might come up as a reporting obligation is the child might not live in the property and doesn't want to have any beneficial ownership in the property because they want, their accountant has said, well, you don't want to be faced with a capital gain if the property is sold and or your parent dies or what have you. So let's make sure that it's documented very clearly that the beneficial ownership remains with your parent and that you're only on title for estate planning purposes only as a bare trustee and agent for the legal change of ownership by surviving joint tenant.
Fair enough.
Okay,
yeah.
But the beneficial ownership and control never leaves the parent. That has to be documented in some form of, like declaration of bare trust and agency agreement or something like that.
Right.
That that you get advice, to structure before you would make that kind of change to title. But that would create a reporting obligation.
Right.
Okay, so now the son is declaring that, yes, I'm a reporting body because I'm holding a half interest in this property for which I do not have a beneficial interest.
Right. And in fact, prior to the Transparency Act, we've probably done many transactions where there were bare trusts in existence, and we may not have known about them.
Oh, definitely not.
Right?
I mean, unless someone volunteers that information, there was nowhere for you to research that.
Right.
But there is now.
There is now.
There is now.
They're getting deeper into our lives. They know all. This is where the Lord of the Ring comes in. The big eye on the mountain sees all,
goodness,
right? I just want one of those rings I can put on where I disappear. I think
it comes with consequences.
It comes
though.
with, yes, it does. Yes, and we digress again. But that's quite interesting. That's very, very interesting. So there are, you made it very clear on some client situations where you might have agreements outside of the legal ownership that are now have become reporting bodies, and that's part of the process that you're going through in your conveyance stage, the final stage, conveying title, where you as a purchaser should be aware that this needs to be reported now.
Yeah. And there's nothing wrong with that.
Right.
It's just, so it shouldn't come across as a scary situation. But
right.
But what's scary are the penalties for not reporting.
Right. And how does, where would a purchase indicate where a trustee is on title? Typically, as opposed to the trustee not being on title. What's the difference there in terms of title registration?
Sorry, maybe I didn't quite understand what the question was there.
Well, when we're preparing an offer for a buyer,
yes,
and there's a trustee involved, I guess the difference is if the trustee is a legal owner of the property, that's what I'm getting at,
right,
then the trustee signs the offer.
Yes.
Right?
The Land Title Office doesn't want to see any other signatures.
Right.
If it's an unregistered trust and it's literally just someone on title who signs that transfer, that's the direct match that the Land Title Office is looking for.
Fair enough.
Yeah.
So if I'm purchasing a property for my daughter who's not age of majority yet, I could be the trustee and she's the beneficial owner, but I'm signing the offer of purchase and sale, so I'm registered on title. Whereas if Bob and Marcy are purchasing a property and they need, for example, it's different now, a co-signer for a mortgage. That co-signer in the past didn't need to be registered on title. They do now, and that's a whole other discussion. But if there is a side agreement for beneficial ownership, like the example you stated, very applicable, where a son or daughter, for example, is on title as a joint tenant only for estate planning purposes, like you mentioned, when the parent or parents pass, the ownership goes to the son or daughter, but they're not beneficial owners. That would be a separate agreement. That would be a beneficial own, a bare trust agreement. Now that needs to be registered. They're a reporting body, correct?
Well, as soon as the trustee is on title as a trustee, that's when the reporting obligation happens.
Right.
If they're already on title and have made that report and then the parent passes, the beneficial ownership is probably passing to the child now.
Right.
So they become...
At that point.
Then they become the full legal and beneficial owner of the property when they're on title by themselves.
Right.
Because their parent has passed.
Right.
So the reporting obligation was when they were having a trustee relationship.
Correct. Got it.
But not when the parent passes.
Right. And that we're getting into this fairly deep, which is interesting.
Yeah.
And you may want to go that route to avoid the capital gains in the property. Right?
Well, that's what that example
That's-
we talked about
yeah.
is your accountant will probably want to see that documentation done ahead of the transfer.
Makes sense. Yeah.
Just to make sure that if CRA comes calling,
Yes.
you can't retroactively do that. That's
No.
not cool with CRA.
No,
No. So you want to have that paperwork done in advance.
Other than that,
and hold on to it to show them when the time comes. Exactly.
Right. Just having gone through tax season. Other than that, they're all pretty cool guys at the CRA and
aren't they
girls.
though? Absolutely.
They're great. Yeah. So, but we won't go into taxes. That's a whole other discussion. So the Landowner Transparency Act and Registry, very interesting, relatively new for many people. And I think this discussion sort of sheds some light on whether or not it's something you, as a consumer and a property owner, should look into. And again, underlying theme for any of our fireside chats, talk to your professional. Speak with your accountant, speak with your lawyer, and get the proper advice before entering into contract of purchase and sale. And how does that pertain to the registration? Because it's all-knowing now. Everything must be exposed, and for good reason. They want that ownership and other agreements to be transparent. So,
Thus, the name of the act.
Thus, the aptly named the Landowner Transparency Act. So, very interesting topic. Certainly one that doesn't apply to everyone, but more and more so. You're probably seeing it.
It applies to. I would just sort of say it applies to every landowner, any property owner in BC.
Right.
Right.
But reporting bodies, yes.
But reporting bodies are very specific
For
obligations.
Sure. And in fact, everybody coming in to sign their conveyance documents will be faced, as you mentioned, with that declaration.
Fork in the road.
Yeah,
absolutely.
You must cross
have
it.
to choose yes or no. It's that simple. And if you choose no, and you technically do have a reporting obligation, you are risking the very severe penalties.
I can only imagine. Yeah. What happened to Gandalf? They locked him in a tower for an endless amount of time while the orcs were traveling through the land. So very similar with a violation of the registry for the Landowner Transparency Act, I'm sure. Great discussion. Thank you, Carolynne. If you have any other questions, I've got Carolynne's contact information behind us. Feel free to get a hold of her and her team, or you can email me. We'll certainly pass that along. Thank you for joining us today.
Yes, thank you. And thank you, Marty.
Thank you.